Hello everyone, welcome to LawPutra's YouTube channel, and our today's topic is effect of conversion on marriage. Before starting with the topic, let's just get acquainted with the term conversion, which is also known as apostasy. So generally, conversion or apostasy implies that the individual has willfully surrendered the religion in the wake of going through some proper service. Apostasy is derived from the Greek word apostasis, which means defection. So in simple terms, apostasy applies to rebel against God or religion. In 1950 Constitution through 42nd Amendment Act 1976 declared India as a secular state, which means everyone has a right to practice his or her religion peacefully. In India, there is a constitutional safeguard for religious conversion as a right to freedom of religion. Moreover, Article 18 of the United Nations Universal Declaration of Human Rights states the following: that everyone has a right to freedom of thought, conscience and religion, and this right includes freedom to change his religion or belief and freedom either alone or in community with others and in public or private to manifest his religion or belief in teaching, practice, worship and observance. But now the question arises as to what are the effects of this conversion on the matrimonial life of the person. So we will be dealing it under two heads, that is effect of conversion in Hindu law and effect of conversion in Muslim law separately. So starting with Hindu law, under Hindu law, conversion serves as a ground for divorce as well as judicial separation. In section 13, clause 1, subclause 2 of the Hindu Marriage Act, if the respondent has ceased to be a Hindu by conversion to another religion, divorce may be obtained. Under this clause, two conditions must be satisfied. Firstly, respondent has ceased to be a Hindu, and secondly, he has converted to another religion. So discussing this topic further, that is ceased to be a Hindu. A person does not cease to be a Hindu merely because he declares that he has no faith in his religion. Moreover, a person will not cease to be a Hindu if he does not practice his religion, or does not have faith in his religion, or renounces his religion, or leads an unorthodox life. So much so, even if he eats beef and insults all Hindu gods and goddesses. He will also not cease to be a Hindu even if he expresses his faith in another religion and even starts practicing another religion. Such a person will continue to be a Hindu. Thus, ceasing to be a Hindu is hardly material except in the context of conversion. Now, after the 1976 amendment, the grounds available for divorce and judicial separation are the same, and hence conversion is now a ground for judicial separation as well. It is important to note that conversion does not automatically affect a marriage tie. The petitioner has to file a petition to obtain a decree of divorce, and if a petitioner chooses to continue to live with his spouse who is converted to another religion, there is nothing to debar him from doing so. Then secondly, it is a non-convert spouse only who can seek matrimonial relief on this. A spouse who gives up Hinduism and adopts another faith cannot go to the court and seek any relief on this ground. This is banned even under provisions of section 23, clause 1, subclause 1a, subclause a, which that the petitioner cannot be allowed to take advantage of his or her own wrong or disability. The issue whether a marriage performed under the Hindu law can be dissolved under the Hindu Marriage Act 1955 by a spouse who ceases to be a Hindu by conversion to another religion was considered by the Delhi High Court in Vilayat Raj versus Sunita. The parties were Hindu at the time of marriage in 1978. And they separated in 1980, and in 1981, the husband filed a petition for divorce under section 13, clause 1, subclause 1a on the ground of cruelty. In the petition, he set out his religion as Mohammedan at the time of filing the same. The wife challenged his right to file a petition under the Hindu Marriage Act 1955 on the ground that he was no longer a Hindu. While the lower court accepted the wife's plea, the High Court reversed the order. It held that the relevant date on which both parties are required to be Hindus in order to file petition under the Hindu Marriage Act 1955 is the date of marriage and not the date of filing the petition. This ground will be available only when the respondent converts to a non-Hindu faith, such as the Christianity, Islam, or Zoroastrianism, and if he converts to Sikhism or Buddhism, he will not cease to be a Hindu, since a person who is a Sikh, Jain, or Buddhist by religion is a Hindu. In Madanand Sita Ramalu versus Madanand Vimla, a husband was granted divorce from his wife, converting to Christianity after marriage. So this was all about effect of conversion on marriage with regards to Hindu law. Now, moving on to the effect of conversion on marriage in Muslim law. Apostasy is called Riddha in Islamic literature. And this has two parts. One is Murtad Fitri and the second one is Murtad Mili. So a person born to a Muslim parent who later rejects Islam is called a Murtad Fitri, and a person who converted to Islam and later rejects the religion is called a Murtad Mili. Before the dissolution of Muslim Marriage Act 1939, apostasy from Islam by one of the married pair would have been treated as dissolution of marriage with effect immediately without the decree of a judge or being a repudiation of marriage, and whether the conversion was before or after consummation. But after passing the act in 1939, it has two aspects. One is apostasy by husband and another is apostasy by wife. So, discussing about apostasy by husband firstly. Apostasy from Islam from Muslim husband will have immediate effects of dissolution of marriage. And Section 4 of the Dissolution of Marriage Act 1939 does not apply to apostasy by the husband. And here, the wife is free to marry another person immediately without waiting for the iddat period. Now, moving on to apostasy by wife. The conversion of a married Muslim woman to a faith other than Islam not by itself operate to dissolve her marriage. So, moreover, even after renouncing Islam, if the wife wants, she may obtain a decree for the dissolution of her marriage on any of the grounds specified in Section 2 of the Act. Section 4 does not apply to women who converts to Islam from other faith and take back her former faith. Thus, for example, if a Hindu woman converts into Islam and marries under Muslim law, the marriage would be ipso facto dissolved on her renouncing Islam and re-embracing Hinduism. However, if she does not re-embrace Hinduism but becomes a Christian, the marriage would not dissolve. So this was all about the effect of conversion on marriage with regards to Muslim law. Now, how can a law topic be complete without some landmark cases? So we shall discuss some landmark cases here. First is Sarla Mudgal versus Union of India. In this, the Honorable Supreme Court has held that the second marriage of a Hindu husband after conversion to Islam without having his first marriage dissolved under law would be invalid. The second marriage would be void in terms of the provision of Section 494 IPC, and the apostate husband would be guilty of the offence under Section 494 of the Indian Penal Code. And similarly, in Lily Thomas versus Union of India, the Supreme Court has observed that if a Hindu wife files a complaint for the offence of bigamy under Section 494 IPC on the ground during the subsistence of the marriage her husband had married a second wife under some other religion after converting to that religion, the offence of bigamy pleaded by her would have to be investigated and tried in accordance with the provisions of the Hindu Marriage Act. So this was all about the topic. Hope you liked the topic and understood it. Thank you.